We're just now we're live on YouTube.
Oh, perfect. Thank you, and welcome everybody to the special meeting of the Citrus Heights City Council, a joint meeting with the Planning Commission. And is Building Appeals here as well?
The City Council and Planning Commission meeting tonight.
Okay. Well, I'd like to call the meeting to order for Thursday, February 25th. Would you please call the roll?
Councilmember Bruins?
Present.
Councilmember Daniels?
Here.
Councilmember Schaefer?
Here.
Vice Mayor Middleton is absent, and Mayor Miller.
Here. Is there any public comment before we turn it over to our illustrious city attorney?
I do not have any public comment for tonight.
All right, then would you call the next item, please?
Next item is our study session AB 1234, ethics training by the city attorney.
Take her away, Ryan.
All right. Yeah, I was so excited.
Can't wait.
I wanted to get going a few minutes ago, but I'm glad you got all through the protocols. In fact, we're going to talk about some of them during this training. And we have a great city clerk who keeps us on the rails when it comes to protocols and procedures and parliamentary procedure and all those kinds of things. But we're going to get through some of that. So I mentioned earlier, we did the harassment training 2 weeks ago that is required every 2 years. Now this one is the other required training. This is ethics training under AB 1234. So I know we have a lot of seasoned council members and planning commissioners, so you've probably been through this before. I'm hoping that each time you get something new out of it and there's some value added. But we're doing it, to be honest, because we're required to do it. The state law under Government Code 53235 says that local agency officials, which includes city council members and planning commissioners, must get this 2-hour training every 2 years. Now, for the new members, you didn't need to do it within a year of taking your office. And so I know for some of the commissioners and for Councilmember Schaefer, who just, they took over in November, December timeframe, actually, you had a little bit more time. So this will jumpstart it a bit. What it means is we now will have 2 years till we'll do this again. So sometime in 2023, we'll get back at it and do the training as well. So what I'd like to talk about when it comes to ethics laws is a lot of people ask me, is this legal? Is this allowed? Does this meet our ethical obligations? And I like to advise, well, sure, maybe it is. And that is, in my mind, sort of the minimal standard. What the law requires is what we have to do. And we certainly are going to meet that. But really, ethics, I think, speaks to more of what we ought to be doing, what we should be doing for transparency for our community so they have trust in what municipal government is doing. So if you ask me a question about legal principles, I might give you 2 answers. Is it legal? Yes. Is it what we ought to be doing, or is this something that maybe isn't the best practice? I might say, well, that depends, or maybe we can hold ourselves to a higher standard. So we do like to think beyond those laws. And to me, the laws really are that starting point for our analyses when we are looking at how we serve the public. It is that floor. We're looking for hopefully higher standards than that when we serve the constituents in Citrus Heights. So if it is legal, it may not be ethical. And really what we're talking about is the biggest thing is public perception, right? So again, if something seems okay, looks okay, how is it perceived by the people who are watching the business that you all are doing? And sometimes I'll try to help when we're analyzing a situation, we'll look at it from that lens as well. So we're going to get into, there's really 4 main topics we're going to talk about tonight. The first one is regarding personal financial gain as a council member or as a commissioner. And then a little different than financial gain is what perks potentially are there, or personal advantages that someone might be getting because of their position in leadership. And we're going to talk to you about what the rules are and how to avoid some of those problems. And then I want to get into an area of government transparency laws. This is, the Brown Act, Public Records Act, those laws. And there's some new ones that have come out. There's an AB 992, which deals with social media. And I sent an email or a memo out to the council members and commissioners, I guess it's probably been several months now, about that. And it's kind of a weird law because it's different than how we normally think what the Brown Act requires. So we could talk about that and get your viewpoints and thoughts. And then the last category is we're going to talk about fair processes and how do we make sure our systems are fair for people who may be applying for things before the Planning Commission or the City Council. What is I group it as fair processes, but we'll talk about those things. So any comments or thoughts as we get going? All right. We'll jump into this. So laws relating to personal financial gain. I think it goes hopefully without saying that you shouldn't benefit financially from your position. And frankly, I'll be honest, I bet most of you are, it's a hindrance to you financially to commit the amount of time and effort that you give to your jobs, especially even when you consider the stipend that you give. You break it down hourly. I find this sometimes laughable because I think most people in public service, their time is more valuable than what they get back. But that's hopefully not why you're here. But we will talk a little bit about those who do take advantage of that position. Not from us, from our municipality, but maybe some examples from other cities and other jurisdictions where they have gotten caught up in some issues that made some public notoriety. So these are the areas I want to talk about. I mean, bribery, clearly, hopefully that's not even something, we will go over it, but we hope that's not an issue that would ever come up. Political Reform Act, often called the PRA. But those of us in Public Records Act also call that the PRA. So sometimes if we use that acronym, PRA could be both of those. And Government Code 1090 is a big law when it comes to government contracts and your inability to engage in a contract with the city while you're also a representative of the city. Talk a little about campaign contributions. Future employment issues, for example, council members, in terms of being hired back by the city that they serve, there is usually a 1-year waiting period when it comes to certain employment opportunities. And then we'll talk a little about serial meeting payment disclosure. It doesn't really come up too often. All right, it is a little bit of a smaller group than last time. We had more staff members because they were required for the harassment. But so because it's a little smaller, feel free to, if you got any comments or questions, just jump in. I can see some people's faces, but I can probably make out your voices. Now, bribery. Public officials are not going to solicit, receive, or agree to any kind of benefit in exchange for the actions that you give. And most of the actions you take are, so usually smaller in nature, maybe an ordinance we're adopting, but every once in a while there are some big projects that come through that potentially a developer or contractor who wants engage in a big contract with the city might do something that you may not even perceive as bribery or some kind of benefit, but you got to be careful. And we'll talk about those things like, if they're offering you tickets to something, or they're offering you certain financial benefits that may not, seem as bribery. It's not going to be that, hey, you vote for my contract for me to be the next, let's say, waste hauler in the city. Here's $10,000. That's pretty rare that kind of thing happens that overtly. It's usually a little more surreptitious than that. But the penalties are stiff. You can see there, including prison time. So bribery is not just the accepting of a financial gift of some sort. It's also any aiding and abetting related to that. So if you're involved in that transaction in any way, that could get you caught up in problems related to bribery. In statute of limitations, it's not when the potential transaction occurred, it's when it was discovered. We actually start the statute of limitations on a bribery allegation. This one goes back a little bit. I want to talk just an example of some kind of bribery types, or we call them self-dealing. And this was regarding the Los Angeles Coliseum. The executive director had engaged in there's a corruption scheme with promoters who were trying to get business there. And so there were kickbacks, self-dealing and bribes that were involved, really to the tune, he ended up paying a restitution of $500,000. But so it was we're talking about $2 million in bribe and embezzlement. And that was a big deal, and it resulted in an individual actually getting prison time related to that. Does anybody happen to remember that one by chance? Yeah. Hopefully all the bad stuff happens down in Southern Cal. So similarly, receiving rewards for appointing somebody. So I don't know who, if you aspire so badly to be a planning commissioner or a city councilor that you're willing to pay somebody council members are getting voted obviously by the people, but let's say a planning commissioner, or let's say somebody else on one of our other oversight committees, they want to pay you for that kind of position. That is inappropriate. They should be doing it because they're the right person for that position. The definition of embezzlement is converting public funds or property to your own use. And if city officials consider receiving unearned pay or misusing city credit card, this was related to a case down in Southern California as well, where somebody had committed these types of allegations and a 5-year sentence for the mayor related to misuse of the city credit card. So the PRA, not the Public Records Act, but Political Reform Act, talks about the personal financial gain and what's appropriate and not appropriate. So let's just say the overall rule when we're thinking about this is we shouldn't be making any kind of benefit financially from our positions. And so if you're aware of something that a vote you're about to take might impact you personally. So we're getting away from, let's say, bribery or these kinds of more extreme cases, but now one where something is going to impact your business or impact your home or impact something, your spouse's well-being or business, in the sense of a vote that you take could have a financial impact. We got to talk that through and see whether you have a conflict where you'd have to recuse yourself from voting on it. So the interests are imputed to spouses and dependents. Some people have asked me about, I remember a council member one time asked me, different city, about a person, their son was coming up for voting. They were voting on a petition that he wanted for some kind of a business. And the son was no longer a dependent. He was a grown child. And technically that was not a violation because he was no longer a dependent. But, my advice to the council members, how does that look to the public if you're voting to approve a project that your son is the applicant on? And fortunately, that council member did recuse himself from the vote. So even though it may not be a spouse or a dependent, someone like that is really close to you, probably has the perception that there's a gain there. There's some kind of insider dealing that's not appropriate. The interesting thing is that the impact could be actually negative as well. So even if you're voting on something that you're changing zoning laws, let's say in your neighborhood, that is going to, in your mind, hurt your home's value financially, you still couldn't vote on that. So the argument of, well, obviously I'm unbiased, I'm willing to vote on, it's going to hurt me financially, you still have an obligation to step down, even if it's a negative impact. So this is, let me talk about this first. A couple of you, I think, and I've certainly gone through this in a number of council members before, have asked me about conflicts of interest. And I'm going to go through the evaluative process. Some I know right off the hand. You know, we could just say that's a conflict. You shouldn't vote on that. You should recuse yourself. But this is the analysis that the law requires when it comes to evaluating, because some of them are closer. Some of them are, well, does this really have a material impact on you financially? Does your action really even impact you financially in any capacity? Maybe maybe it's a decision that impacts everybody in the city. That wouldn't be a
Ryan, I don't know if you can hear me. It sounds like you froze.
Yeah, I can't hear you anymore either.
Well, do we get our certificates now?
Amy, if he's in the office, can you call his extension there?
Yeah, I just texted him and he just responded.
It worked in rehearsal.
Looks like he,
How about now? Can you hear me again?
yes.
Yeah,
we can
perfect.
hear you.
Thank you.
Yeah, I mean, I came into City Hall thinking that the Wi-Fi would be better here than in my office, but maybe not. Can you see my screen again?
Oh,
do.
not the presentation, no.
Here we go. Yes, we can see it.
You could. Yeah, Amy, if you could let me know if I freeze. Thank you for texting me. Even though we're both in City Hall, we're in opposite ends of the building, so I don't see anybody physically here. So this is the analysis that I would go through. First is it reasonably foreseeable that the government decision that you're making would even have a financial impact on you? And so some of the decisions you make, they're not going to meet that threshold. There is no financial impact. And so if that answer is no there, we end the analysis. We don't have to keep on going. But if the answer is yes, okay, it makes sense that there might be some financial impact on you. The next step we're going to take is it material? And material means, is it something that of substance, right? So if we're talking about just a few dollars here or there, then that wouldn't reach that materiality. It's got to have a certain level of substance to that conflict financially for you to have to step down. So that's where sometimes I'm going to go through a little more deliberative analysis to help determine whether there is a conflict. And then the third step we're trying to figure out is, do you have a distinguishable interest that's different than the rest of the community, right? So every vote you take in some ways probably has some kind of potential financial impact, right? So if you're approving a housing project in the city, well, that has some impact on you, or an ordinance related to whatever it may be. I think there's arguably a financial impact in those, but the same impact for you personally is the same as any other citizen in the city, or at least a good group of citizens, then you're not going to have a conflict and you can vote on that item. And then the last step in this is, if all these apply, then you cannot participate in making or attempt to sway others in the decision process for the city. So I'm just going to go over a couple of these, what a financial interest is and what rises to that level. But what I would like the takeaway to be is, if you think you've got an issue, let's talk it through. Let's see what we've got. And I can help go through these processes to see, as opposed to you trying to figure it all out right now and determine, okay, I don't have a conflict, or I do. I think there's value in going over it together. So an interest in a business entity is valued at $2,000 or more. So if you have a very small interest or a smaller interest in a business, you're an investor of $1,000 or less, you wouldn't reach that threshold of having to recuse yourself. And these are the types of actions we're talking about where a business holding, a person with a holding would need to recuse. If they're initiating some kind of proceeding, they're entering in a contract with the city, they're applying for some kind of entitlement, a regulatory act, or the entity is subject to an action taken solely directed at the entity. So there are some, the question is it rise to that level? But there's also additional expenses, and I don't think it's even value necessarily in going through the minutia of, are the expenses going to be such that it reaches this threshold? I think what we do is if we think it is close, it's something we'll talk about. But in certain businesses, you can see there's percentages of gross revenues is whether it meets the threshold or not. Small investments. So some of you, well, you all have to do Form 700, which again, we'll talk about in a bit. Sometimes a part of the Form 700 is, it asks about your stock holdings and other investments you may have. If you have a stock holding of less than $25,000, and represents less than 1% of the stock, that is not considered a financial interest, which rises to this threshold of having to disclose it and recuse yourself. I think real property is the one that is the most common, that we see the most often when members have to recuse themselves because a project is close to property that they own. I don't know if you realize this, but the real property interest actually does have a value. So if you owned a portion of something that was valued at less than $2,000, that would not rise to the level of having to recuse yourself for an investment. I don't know what real property there is in the city of Citrus Heights that's worth less than that, but I suppose if it was a small portion or maybe like a storage facility where you had part of it, that would be considered a real property interest. You also don't need to own the real property for it to be an interest. If you're a tenant or, in that capacity, or you lease it, you would potentially have to recuse yourself. So the kind of decisions we're talking about is, development plans, rezoning, maybe taxes, fees, or assessments that could apply to the property. Other types of impacts on property would be, certainly sales, purchases, or leases of property in the neighborhood, or even the one at issue. Issuances or denial of license, entitlements, and variance, that applies more to Planning Commission, as they're doing a lot of entitlements and variance approvals. And then in construction of improvements of streets, water, and that is something, right? We've done the complete streets approvals of late. If those are streets that are impacting you, that are on your street or nearby, and you think potentially has a financial impact, or just has the perception of, well, why are we paving, the mayor's street and nobody else's? Then you may want to recuse yourself. I think you've probably heard, when it comes to property, this 500-foot rule, right? That's kind of what it's been for the past. That you within 500 feet, that is from corner of your parcel to the corner of the adjacent parcel that's being affected, you should recuse yourself, because that's close enough that people think, or that the government thinks, that you have a financial interest worth recusing yourself. Those numbers is now a guideline, so we'll talk about that. If you're within 500 feet, I'm going to advise you to recuse yourself. I think that is pretty much the presumption, is you have a conflict because it's close enough. The frame with which you may or may not have a conflict is between the 500 and 1,000 foot space. So you look on a map, and we can help you do that. Certainly our planning department has really good resources to see, okay, my property is here, and the adjacent property, or the property that we're voting on, looks to be about 900 feet away. That now is in the in-between stage of whether you should or shouldn't step away. I think it depends on what kind of project we're talking about and how much impact it has on you and your property. So property that's over 1,000 feet away, the law presumes that you do not have a conflict, and that you could step away. But what is the current trend now is that the numbers, the feet aren't just the be all end all. If you lived 1,001 feet away, but it was a major development that was really going to probably have a lot of maybe vehicle traffic coming down your particular street, that's one you may still consider yourself to have a conflict and want to recuse yourself from acting on. And same thing, in theory, if you're within 500 feet of a project, the law used to be you had to recuse yourself. Now you don't, but I think the prudent practice would be to do so. Any thoughts on the real property interest? Does anybody have any maybe examples that they've had to recuse themselves because of property and that's something they're willing to share, or thoughts on that?
Yes, me. I've had to recuse myself twice. Once was when we did the big mobile home thing in 2006. And under the current project we have for the electric greenway, I'm recused from that because I live within 500 feet of it.
That's right. Yeah, I helped advise on that latter one. And those, thanks, Councilmember Bruin, for sharing that. Those are exactly the kind of projects that we're talking about here. Is something, does electric greenway really have a financial impact? Maybe, maybe not, but it's the percentage that it makes sense for the council member to step away. So this is source of income. This is different now, property. So if somebody is a source of income to you and they are, let's say, an applicant for something, or they have something coming before the city. So my example would be if I'm a whatever my business is, let's say it's my legal business, and one of my principal clients is somebody who's applying for a variance for the planning commission. And that client has paid me over $500 per year. Let's say they're paying $1,000 per year. That would be considered a source of income that rises to a financial level where I should recuse myself, because the theory is that I want to help this guy out because he's going to keep hiring me to do business for him or her. So other sources of income, it says it's a named party and the subject of the decision, including a claimant, applicant, respondent. So we're talking about somebody who is coming up before the city for one of these items. An individual person as a source, that's the example I just used as opposed to a business. But if an individual person is hiring one of you or is a source of income to you, and that one is $1,000 as opposed to $500, you should recuse yourself from voting on it. Does that make sense to you all? I mean, if you're in the business of whatever you do for a living, and you see one of your primary persons who provides that income to you, does it make sense to recuse yourself? Yeah.
Yes. We'll speak after.
There's a little bit of a variant when it comes to nonprofits, and so I don't need to get into the exact, but you can see some of the dollar figures modify itself. So if a nonprofit is an applicant or is doing something that's going to be impacted by the city, and you are maybe on the board of that nonprofit, or you benefit financially from that nonprofit, meaning they're your employer, you got to consider stepping down. But it is different than a private person who's applying. And you can see the decision's got to be revenues that are a little bit higher than normal.
So Ryan, I have a question for you.
Sure.
Back in 2013, I used to run the Chamber of Commerce in Citrus Heights, and I left in 2005. And in 2013, they hired me back for an interim period because they had gone through some challenges. And I was part-time, and it was going to be a contract basis. And then Ruth Ann said that I needed to be an employee of theirs because then I would not have a conflict of interest. So they basically hired me back as a part-time employee so that I could do the work there and not run into trouble. I was there about a little over a year, and then I was done. So, but if I'd been on contract with them, that would have been a conflict of interest. Does that make sense to you?
Yeah, it does. There are very weird and specific rules about nonprofits when it comes to the employee relationship. And I think that is still the case today, even though whatever, that was 205 to 2013, I think you said.
It was in 13-14. I left in 05 and came back in 13-14 for a brief period to help them through some troubled waters. So
Yeah, I think you probably didn't have a conflict either way, but I think by making you an employee on a part-time basis made it even more attenuated and less so.
okay, really? Okay, well, we survived it. Thank you.
You bet. So when it comes to the nonprofit, if they own, real estate in the city, that's going to be something that's going to impact the decision that you might have to step away from. Government entities also, if you work for a government entity, then you also would have to disqualify yourself if that government entity became, like, every once in a while we have contracts that we do with Sacramento County. And if you were an employee with Sacramento County, that would be something you'd want to step away from making that decision, because the idea is, well, you'd want to help out your employer in theory, or the perception is that you would do that. So sources of gifts as well is a little different topic we're going to get into here. So certain people when you fill out your Form 700, you're supposed to put any gift of $520 or more in a calendar year, as well as individual gifts of more than $50 per occurrence. If somebody has given you a gift in excess of that amount, then you can't vote on any item related to them. And that's why you put on the Form 700, because in theory, the Form 700 is a public document. And if somebody wanted to know, hey, what does Councilmember Jones have, what does he, or his financial interest, and who are his sources of income, they can go look at the Form 700 and see that if the source of that gift was on there and you're voting on something that gift source has given to you, then you'd have to recuse yourself from voting on that as well. For my guess is that you haven't received gifts to that amount that's required reporting, but if you have, let me know. The source of gift, if it's a nonprofit, there's also a different standard for that as from related to business entities. So the financial effect is on you and your immediate family, and it's material when the official or the immediate family member will receive some measurable benefit or loss from the decision. So that's kind of the sum of what a financial interest is. And if you have any questions with that, let me know. Some exceptions that I think are worth noting is that retirement policies aren't applicable to this. So if you're retiree from somewhere, you don't need to recuse yourself. Also, travel costs paid for attending meetings is not considered a financial interest. Stipends for attending meetings of a body created by law would not be a financial interest. And use of government property while carrying out those official duties is also an exception to that. Sorry, my screen is covering it. And then you are allowed to get rewards. So if you use for example, you travel on the government's dime for something that they're reimbursing you on, you can have the benefit of the rewards program that may be associated with that. So if you fly on Southwest Airlines and you're a Rapid Rewards person, you're allowed to keep those benefits. You don't need to give them back to the city, even though they paid for the travel. Okay, self-appointments. I've seen this come up a few times where somebody is, in fact, we had the mayoral appointments recently, and people asked, well, can I vote for myself when I'm up? And the answer is yes. You can participate in a self-appointment when it's related to you being an officer in your own entity or in some other JPA or the library district or something where you're representing the city of Citrus Heights. No, we don't need to get into all those. So the question I wanted, when you are disqualified, the question is, what do you do about that? And I think Councilmember Bruins mentioned before that she had disqualified herself from a few of those. And I recall what she did is she stepped out of the room, physically left the room. And that was the way it is supposed to be held. There's a few new rules with the FPPC that I wanted to highlight regarding that. And I also sent a memo on this one about a year ago. When you recuse yourself, you are supposed to state on the record what the basis of that conflict is, right? So it used to be, though, people would just say, oh, I'm stepping out, recusing myself because of my financial interest in this, or I live within 500 feet of this project, and that was it. Now what the FPPC is saying is that you need to actually state, if it's your business, where you work, meaning the name of the employer, and your position with the employer. If you're recusing yourself because of real property interests, you need to state, at least in general terms, where you live. You don't need to give your address, but you're going to say, I live in this street and this is where it's impacted. So they want a little more specificity with which you're announcing that recusal. The other new rule that came in is when you come in early, it says entering late or leaving early. So from a meeting, if you didn't attend the beginning, or let's say you left the meeting early because you knew the last item you had a conflict on, you're supposed to, or at least somebody is supposed to announce why you left. That way you don't just leave and then it's just like, well, member so-and-so was absent for the vote. The member was actually absent because they recused themselves. And same thing, if you came in late to a meeting and the vote already occurred for a topic that you had a conflict on, you needed to announce what that conflict was. So, go ahead.
If we think we're supposed to recuse ourselves, we can then just state what it is and why we are, and then you would be in the position to tell us whether or not it was necessary.
Correct. Ideally, I would like to talk to you before the meeting as opposed to right there at that time. So if you think you have a conflict, let's talk about it beforehand. But sometimes you don't realize it until you're there, and all of a sudden you look and you're like, wait a minute, this is close to my house, or whatever the case may be. You could then make the announcement right there in the meeting that I have a conflict, or you could say, City Attorney, do you believe I have a conflict? Should I recuse myself? And I will give you my opinion there. I will tell you that probably my opinion, if it's on the, at that moment, will be more conservative to say it makes sense to recuse yourself, unless it really is, no kidding, just not an issue.
Okay, thank you.
And what I also will help you with is if you make the announcement on your recusal and don't quite state it, all the things that are now required by the law, I can help kind of push and prod that along a little bit to say, so Commissioner Engel, can you explain where is it you live, or what the nature is of your position at your job that you think presents this conflict? So I'll be there to help. So now the good part about Zoom is instead of just leaving, having to physically get up and leave, you just click the camera off and you're good to go. So that way you don't have to physically step out of the room anymore. And this, I know it's come up on consent calendar before, and we did have this, at least within the last year, where somebody had a conflict on consent. You don't have to leave the room unless that item is pulled from consent. But what you want to make clear for the city clerk on the record, I think usually we do a good job of this, is that you're not voting on, let's say it's item 7, but voting on the other items. That way when the minutes are reflected afterward on that particular item on consent, you didn't vote on it. Does that all make sense? Most of these I think are hopefully commonsensical. So why do we get into this? Not only is it required, but it also does potentially have ramifications legally, right? So you're talking about if a decision was made where there was a conflict that could invalidate the decision, we have to redo it. but certainly when it comes to, bribery, embezzlement, like the big ticket ones, there's going to be fines and penalties and potentially crimes associated with that. Any questions or comments there? All right. So Government Code 1090, this is sort of a little bit of a nuance related to the Political Reform Act that we talked about before. This is really for contracts. So I had a friend who was a concrete construction guy, and he wanted to run for city council in a different city. And he was a main construction guy in that city and had big contracts there. And he realized before he was going to run and decided not to run because he knew that had he won, he would lose he could not engage in those contracts with the city after he was elected. The difference between the Political Reform Act issues that we talk about and Government Code 1090 is you usually can't just step out of the room and recuse yourself and allow your colleagues to vote on it. It is considered a conflict that is translated to all of your colleagues. Because the theory is, well, if we like Steve and Steve's construction company, he's not voting, but we'd like to give it to him, then that's potentially a problem. So that's why it says abstention generally is not enough to get out of a Government Code 1090 issue. There are some exemptions, and that's, you can have full exemptions or partial exemptions where you can still vote on it. But for the most part, it's when your ownership is really a small interest here. So as you can see, an exemption where you could still vote on it is if you had a small interest in a business, or if it is interest of that of an attorney or other contracting party. There is some exceptions there, but it only applies if your firm did not receive any compensation for services, or you had less than 10% on it. Basically, pro bono type work. Smaller than, you had 10% ownership in a bank. Again, there's a lot of nuances to these that I don't know that I'm trying to flag them and identify issues for you that we can deal with if and when they come up. For partial exemption is if it's a small business, you have 10 or more employees, and you have been an employee the last 3 years prior to entering the office, and you own less than 3% of the stock, you're not an officer in the company. Those would be times where you could be exempt from that, and you still allow your colleagues to vote on it. Okay. Other special exemptions for specific types of work like engineering. So also for nonprofits, this kind of relates maybe to what Jeannie was talking about before, but that was really where she was an employee. You can be exempt if you're an uncompensated officer of a nonprofit, or partially exempt for officers and employees of the corporation. I'm trying to change my screen around here. So this was a case I wanted to highlight out of Fresno when it just said that independent contractors would be considered employees for the purposes of 1090. So that is, for example, would be myself, right? So if I'm not an actual employee or an elected official with the city, but still am an independent contractor, I'll be treated as an employee and should still recuse or not be involved in something. So if my contract was up, you'd ask for outside counsel to review that. 1090 violations are a big deal. And so this is what speaks to that. The contract could be void, it could be a felony. You certainly could have to refund the money and pay attorney's fees associated with that. This was one particular case. We had an elected official who was in the travel business and recently failed to, a couple times over the past couple years, failed to disclose that business on the Form 700, and then voted on a consent calendar item that included payments to her travel agency to the tune of almost $28,000. The result was she had a fine of about that exact amount, $29,000, but faced even more than that. So campaign contributions, you can't, so elected officials of an agency may not receive or solicit campaign contributions of $250 or more from people financially interested during a preceding 3 months, of a proceeding and for the 3 months thereafter. So you're allowed to get campaign contributions over that amount. They just can't then be, you can't be involved in any kind of decision related to that person for a period of time. I mentioned this earlier that there is a future employment related issue. So you can't participate or influence any decision in which involves someone with whom the officials your future negotiating employment with. So if you're about to leave the city council or the city and you're helping that particular entity with that project with the city, you can't do that. There's also this revolving door prohibition. So for 1 year after leaving office, you can't come back and lobby for the city. So if once a council member is off the city council, and maybe a company, let's say there's a home developer that wants to come in and wants to hire you as, we'll call it a lobbyist, or somebody who's going to then come back to the city council and try to push for that particular project. You can't do that for 1 year from leaving the city council. I haven't seen this one come up before. I'm curious if our city clerk has before, but this is the idea of the city clerk or a council member is to make certain announcements at a city council meeting if we're about to convene another meeting within that meeting. So sometimes we do the, successor agency might have a meeting. And if you're supposed to announce if there's somebody who's getting compensation, what compensation that's separate from their council compensation, that if they're going to be voting on a particular item with related to that. So I don't believe that the city, correct me if I'm wrong, does the city council get any separate compensation from being on other agencies within the city?
No, I think it's just the regional boards, Ryan. Nothing in the city.
Yeah, so so those regional boards, you're not having a meeting there at City Hall. You might have a meeting there at the Library Commission or whatever, but sometimes, Mayor, there are times where we might have a special meeting where you're acting as the successor agency, right? And a redevelopment agency when we had that. If you were getting separate compensation related to that, there would need to be an announcement about that compensation. And I don't believe.
This sounds like City of Bell.
Well, we do that at the regional stand. That announcement is made at the beginning of every meeting. And so they're just super cautious.
SACOG does it too, I believe. Because there's a couple other boards you sit on, but you don't get reimbursed for them separately.
Do you get a stipend for being on those boards?
Yes.
From SACOG, yeah, but
Yeah. Well, that's probably why they have their own separate counsel who's probably going to advise on that. When it comes to city stuff, I'll be the one helping advise whether we need to make, along with Amy's help, whether there's the announcements, but I'm not aware of any. Okay. So the takeaway from all this financial thing is let's avoid the temptation to look at public service as some kind of opportunity for public gain. Again, I'm going to go back to the beginning and say I think you're losing money most likely with what you do here because your time is worth a lot more. You're doing it because you want to be here. But please look at every decision and ask yourself whether there is some kind of financial interest related to you or to one of your dependents. And if so, I ask that you please talk to me before the meeting, or if it comes up during the meeting, we'll deal with it there. Any wrap-up thoughts on that one before we move on to the next section?
Ryan, one of the things I wanted to ask, because you talked about like the on decisions within 500 foot or 1,000 foot of your home. Can you talk about some exceptions, like I could see recusing myself if we had a street paving project that included my road. But if they went and paved Old Auburn Boulevard from one end to the other, would I have to recuse myself because I'm within 500 feet of that project? Or is that to the public good?
It's going to depend on how many people are involved. So if you're talking about, no kidding, a project that infects, let's say, several hundred, thousands of people, then I don't think you have to recuse yourself. If you're talking about a repaving thing that only implicates, 50 to 100 lots, I would say that that's more of a specialized interest that you have that you would want to recuse yourself from. So it is a very factually specific driven discussion of whether it used to be just if it was within the time frame or within the space. Now it's going to be more of, is there something special that impacts you as opposed to other people in the community? And even though that particular street may just be your street, if it's all of Auburn Boulevard, that is a cross section that impacts a lot of people, and probably you wouldn't have to recuse yourself.
Thanks.
You bet.
Anybody else before we move on? No perks.
No perks, sorry.
Oh, shoot.
Yeah, you're getting so many great perks until you got this briefing, right? We're going to talk about a few of them, just highlight a few things. You shouldn't be receiving special benefits because of your position, right? So there's some gift limit rules. I mean, let me ask you, how often does the gift issue really come up for you guys? How many, are there that many times where the gift issue is presented where you feel like you need to talk to council about it?
Once in a while, we would have somebody give too much, and that's where we give it back to be given to the community or something, or employees. Just overzealous gifters.
Well, cap to cap, we claim dinners and stuff just to be safe.
Yeah.
We're going cap to cap.
Yeah.
Yeah, those are definitely gifts, and I've seen other council members from other cities get busted for that because there's all these eyes back there, and you don't put that dinner down, you're in trouble.
Well, or people who are smart know that the gift limit is $50, right? So they might do a lunch or something that is less than that, is $30 or $25 or something, and then you don't have to report it, provided that there's not subsequent gifts later on in the year that get it over that threshold where you do need to report on your Form 700.
Right.
But I know, like, a lot of League of California Cities events that I'll go to, it's on the Legal Advocacy Committee. We get a lunch that doesn't look like it's worth more than $8 or something, but they'll give you the little card to say, here's what it costs them. It's usually way more than $8. It's like a $20 lunch, but they overpaid. They're giving you they let you know what the amount is so you could report it if you need to. So we get gifts, a little bit about honoraria. That's the idea that if you go somewhere as the mayor or a council member, they're going to give you some benefit for being there, maybe a token of their appreciation. Then some things you got to give back or give to the city and let them redistribute it somewhere else. Gives to public funds, and then we'll prohibition on free or discounted travel. We'll get into some of those. So gifts not just money, right? It's anything that confers some personal benefit for which the person did not provide goods or services of equal or greater return. And so if you work for something, you get something that makes some sense. But if you're getting some benefit because of who you are in the city, that's considered a gift. Could be meals, entertainment, lodging, lots of different types. Okay, so the rule is that you can't accept any gift worth more than $520 in a single calendar year. That number goes up each year. I remember when I first was the city attorney, it was in the 400s, and now it's $520. And that's over a calendar year. So if someone gives you Giants tickets valued at 500, well, wish they were playing, but let's say they are playing next year when the season finally gets back underway. They give you $500 worth of tickets. They think they're good, or you think you're good from not having to not accept it. You could accept it. The problem is if in January of 2022, which is still within the calendar year of today, they give you another, well, at that point, just $30 more or $21 more, you'd be precluded from accepting that gift because it's now breached that rule. Does that make sense?
Yep.
Yep. And so you're disqualified from participating in pretty much any decision relating to that person who gave you the gift.
So Ryan, so
Yeah.
let's say in that scenario, you went to the game and you used the tickets, and then they gave you, a $500, and then they gifted you something else that was $50. You just got to give the $50 back and make sure it
Yes.
stays under the 520, or okay. Oh, okay.
Correct. Yeah. So if they give you something else, you got to figure out what the fair market value of it is. If it's a ticket, usually you know, but if it's some other gift, you got to figure out what the value is, and you can accept it and just pay them back that amount to get it below that threshold. Where people get into trouble is, they stay in the suite at at the Giants game, and the value of that is maybe several $100s, especially if they let you and bring a whole bunch of other people with you. So people sometimes get into trouble when they stay in those like luxury boxes or something like that because they don't know the value. Now, the bottom line is important though. Just because it's under 520, which means you can accept it, you still got to report it on your Form 700 form. Anything over $50. So if somebody gave you $55 gift certificate because, this is the tricky part. It's because you're a city council member, not because it's if it's your family member or friend, they're giving you gifts because hopefully they like you as a family member. But if it's because you're a council member, and usually you can tell because it's who it's coming from, right? It's a potential contractor or somebody who wants to do business with the city. That's where you got to report it. So people started to get around this with what they called behested payments. And now you do have to report it in something called a Form 803. So if a public official requests someone to donate to let's say the nonprofit of their choice. So if you're a public official and you really believe in SPCA, or you believe in the Boys and Girls Club, whatever your organization is that maybe you're a board member of, there were contractors that were donating like tens and hundreds of thousands of dollars to their entities that wasn't going to them directly. It didn't, in theory, have a financial impact, but it certainly made that elected official happy, right? Because you benefited their group. Now you can't do that for, you have to report. You can do it, but you just have to report it now if it's over $5,000 annually. But if you see that second to last bullet, there's really no limitation otherwise in terms of how much they want to donate. This one I think we'll go through fairly quickly because tickets gets a little nuanced based on whether it's a ticket from a nonprofit, ticket to a political fundraiser, ticket from a third party. But tickets sometimes, back in the day when we went to events, was the thing. If the River Cats gave some tickets to the city or to a public official, you're allowed to take a certain number of tickets. If it's if you're being asked to be served or recognized as an official, that's fine. But it's got to be usually it's only 2 tickets and it's got to be reported. But we'll get into that. So you do need to adopt a ticket distribution policy and follow that policy. It must show some valid public purpose, and the giver and user of the tickets must be disclosed on a Form 802. And then we post that on the city's website if there were tickets that were being provided. So the giver and user of the tickets must be disclosed on the Form 802, and you can identify the person's name, the date of the event, the value of the ticket. And again, that's going to go on the city's website, and you also send a copy to the FPPC for them to have on their records. There is an exception if it's distributed to department of a city, so it's not used by a council member or appointee or even the agency head like the city manager, but it was going to other. You're not beholden to this rule if it's going to other city employees, but the name of the official doesn't need to be reported, but the number of passes would still be reported on that Form 802. The third party who gives the tickets can't pre-designate who receives them. So if they say, here's 10 tickets, but they're earmarked for these people, they're not allowed to do it that way if they want to do it without being reported. You can't then turn around and give the tickets to a non-relative. And certainly the exception, I think, is, Councilmember Schaefer was mentioning before, is, look, if you want to pay the face value for the ticket or return it, that's not going to be an issue. And there is an exception for a ceremonial role or function that we're going to talk about, but that's limited. So if the local, the River Cats want to have a night where they honor the city of Citrus Heights and they give a couple tickets to the mayor and vice mayor to throw out the first pitch, then that's probably going to be okay. So from nonprofits, tickets, we're going to talk about tickets from a nonprofit versus a third party. There is this 2-ticket rule. So if you only receive 2 tickets, you do not have to report them if it's from a 501c3. So additional tickets would be required of the same limits and disclosure requirements, and the value of the tickets can't exceed that special $520 rule. So if tickets are received not from the actual 501c3, but from a third-party person, this rule does not apply. You can accept a ticket, but you have to report the value of any of the food and the entertainment related to it. Again, the 520 rule, and you can pay the value down under the limit. This is the example we talked about before. In some cases, you may be asked for a ceremonial function to come, and that there are special rules for that. But in order to use that ceremonial function, the use of the ticket must be disclosed on the Form 802 and sent to the FPPC for them to post on their website. Not to be confusing, but that's not considered a gift. That's you coming as a ceremonial rule, so you don't report that on your Form 700. So sorry for the confusion, all the different forms, but this is why we can help you walk through it all. There is a little caveat, and if a public official receives tickets to an event where one of these exceptions does not apply, you should assume that those tickets are now basically a gift and would be reported on your Form 700. Political fundraisers is a little bit different. There is a 2-ticket rule as well, but you do not have to report it. You can pay down the value if it gets over a certain level, and the tickets can be given directly to the spouse is not counted. So ticket rules, we always end up every group of slides with showing you what the problems are, and here's the penalties. Obviously, you can not only be embarrassed, but you can have criminal issues and liabilities affiliated with that. Honoraria, maybe something that could apply to you, I don't know, but I wanted to at least touch on that. You can't accept, the basic rule is you can't accept honoraria. You can't go to some event and they're going to give you some gift because you're there. You're allowed to be there, and there's those exceptions for paying for in a ceremonial capacity to come to, let's say, an event. But to then give you a token, some gift, a gift card, whatever the case may be, is the general rule is you can't accept any of those kind of honoraria. And that does apply not only to council members, but to city employees as well. Anybody who files a Form 700, which is all department heads, are going to have the same honoraria. And I could see that applying to like a police chief, right, or a city manager. Those types of officials could be asked to go to events, and they have to be very careful about what kind of benefits they give, because maybe the police chief is asked to give a speech or do something in an event, and he's got to be careful about accepting, he can't accept any kind of payment for that.
Thomas Sheeler, you have your hand raised. Did you have a question?
Yes, going back to the tickets issue, and Ryan, you talked about being able to pay down to get under the 520 limit. But how would one, not that I anticipate having that problem myself, but I mean, how would one document that pay down and sort of withstand the public review of that?
Yeah, so hence anytime you're getting up near that 520, because to me that's a pretty substantial amount, right? If you're accepting a ticket in the $50 to $100 range, you're not getting close to that. But if you're in that several $100 range, I think you're playing with fire anyways, and you probably want to be careful not to accept that. But I think what you do to do the pay down is you would ask for a receipt, or you would draft at least a memo or an email saying what I got and what you sent back in return, and that they accepted that pay down and what you think the fair market value was of the event. And that way you'd have it as some kind of documented record. Is it worth it in the end? To me, I don't think it's worth the scrutiny you're trying to go through that.
Thank you.
Ryan, I got a question. So let's say that I went to an event and there was and I'm not there in any official capacity, but I happen to enter a raffle and I win the raffle. Is there any issue with that? That if, let's say that I win $1,000 item on a raffle, is there any conflict there? Or I'm not there in any kind of official capacity. Could somebody I'm sure somebody could level an accusation that.
Yeah, so the answer is no. There's no conflict. There's no issue with that, as long as it was really a raffle. The problem I've seen, I've been to these League of California Cities events where they have, let's say, those tables you walk through. Someone who's been to these things, and they'll put a business card in there, and they'll be raffling off an iPad. And ironically, somehow the business card they pull out is the council member for the city they're trying to do business with. So that one kind of reeks that there was some kind of non-really raffle thing going on, and they got it who they wanted it. But I think Councilmember Schaefer, if you see the ping pong balls bouncing around and there's 100 other ones and 1,000, and no kidding, just landed on your ball, then more power to you. You just got yourself a $1,000 gift. I think you're okay.
Okay. Great. Thanks.
Yeah. There's always a perception. What you may want to do, and what a lot of elected officials will do, if they win something like at a big Rotary event or some city event, is they'll just donate it right back there on site. But that's just because they want to be a good person. You don't have to legally do that. So the honoraria, you can within 30 days of receipt give it back. They have a certain window. They don't want you to keep it for 6 months to get the benefit of maybe it was a car they gave you and then give it back. That's a way to, and you don't get to claim some kind of deduction on your taxes for returning it, which would be awesome if you want a car. So gifts of public funds, this is the idea that you can't use public funds or resources for your personal use. I like this example. I said, I want to ask the police to serve as your security guard for your party. So, we're not going to go talk to Lieutenant Morris and say, hey, would you be the bouncer at my house for this party, and not pay him, and just say it's because I'm a council member and I like your time and benefit, even though he looks tough. We're not going to do that, because that's a gift of public funds. That would be the time, especially if he's on duty. That's time that would be a value to the city that's now being used for some kind of personal benefit. So the test at the bottom is, does the expenditure serve the public interest globally, right? Not just a small section. The prohibition on free or discounted travel. This is one that I just got briefed on myself as an Air Force member, as a Guard member. There's been some issues of people who are in uniform and they showed up to the airport, and the really nice person at Delta says, "Oh, you're in the military, go to first class." Well, you can't do that because you're getting a benefit because of your uniform, because of your status in the military. They claim there is a rule. They say it's okay if you want to board early, which I think is a bad look, but you're allowed to accept that benefit because there's no real financial component with that. But let's translate that to council member or planning commissioner X. If somebody is trying to give you some benefit or a free or discounted travel because of that, because of your position, you can't do that. You can't accept that. And that violation means you could actually lose your office because of it. I don't think that's come up. Anybody ever been offered a free cruise because you're a council member or discounted?
No free cruises, but free flights. But they've come from my sister who works for Southwest.
I think that's okay.
It better be because she used her. She earns so many tickets and she hands them out to family members.
I wish I had a sister that worked for Southwest. That'd be nice.
Isn't it?
You bet. So that one's that one. So expense reimbursement, you can, if you're traveling, I think Cap to Cap is a good example, or going to League of California Cities, you don't have to lose money to go on those things. You just have to be very cognizant of your receipts and what things are appropriate for reimbursement. If you're, no kidding, going on city business, if you're going to Washington, D.C. for a week and you only had, and they're paying for your hotel for the week, but your business was only for one day meeting with the local congressman, then that's not an appropriate, you can't get reimbursed for the lodging for all of that. Usually the lodging rules say it's got to be the day before the event and the day after. If the conference is 3 or 4 or 5 days, then great. That makes more sense and that is okay. So Mayor, when you did, have you done Cap to Cap? I know Councilmember Bruins.
Oh yeah. Oh yeah.
How is that reporting done? Is that an issue with the expenditure? Do they just book it for you with the city, or how do you get reimbursed for things?
Well, number one, and I see need receipts, and that's something I learned because you may have a valid charge on your card for a meal, but if you don't have that receipt to show you weren't buying alcohol or anything extra, you're not getting reimbursed. As far as reporting goes, like Kaiser would put on a dinner, you go to that. They usually send you a letter, the dollar amount of that dinner, and then I tax them on. I always overestimate. I just rather be safe than sorry. But yeah, we need receipts for everything, from the extra $25 for a bag to anything you might be charged.
Yeah, you're right. But it's, if you ask for the drink on the plane that costs $10, I hope you're not putting that one on for reimbursement.
Nope, you're on your own. As long as you pay for it yourself.
Yep. And, the bottom one is a big one. A lot of people do bring a significant other with them. Now, the transportation you're going to be paying for, the lodging, if it's the same cost for 2 people versus 1 person, then you just get the windfall benefit of that. But we're not going to be expensing anybody's partner to go with them on these things. So somebody mentioned Bell and Vernon. So the Bell one always, this is basically the reason we do this training, is thanks to the city of Bell. This goes back, well, it's been a while now. It's been probably 15 years. I think it was the early 2000s when the city of Bell and eventually Vernon, they were giving crazy amounts of salaries and loans to council members and to the city manager. I mean, to the tune of like $800,000, $1 million loans that were going to be non-reimbursable, to council members. And Bell was a city that in Southern California and Los Angeles County that had very few population and had very few oversight. There just weren't a lot of people that were aware of what was going on, and so they unfortunately got away with it for a while until the district attorney came in and the city manager and assistant city manager are now in prison for, 11 and 12 years respectively because of basically the stealing of millions of dollars. In Vernon, they did this is also sitting in the same area. They had a $1.6 million salary. This is for I think the manager, plus hundreds of thousands of dollars on first class flights, luxury hotels, and limos. So they were living the high life on the taxpayer dollars. The council members in Bell pleaded no contest. They faced a prison term, but in the end, they didn't get prison term. But the city manager and assistant city manager there, you can see, did get for fraud, charges of corruption and tax fraud, did serve double-digit years in prison. Whether they serve them in the end, I don't know. I think they're still in prison now from sentences, though. So you end with that crazy story, but let's avoid the perks and temptation to try to rationalize them in some way. I know you guys work really hard and do deserve some kind of compensation or benefits, but that's just not the financial way to get it is not going to be there. It's going to be hopefully it's because of the goodness of your heart. So transparency laws, this is where I feel very grateful that we have an awesome city clerk and assistant city clerk that know all about the Brown Act and the posting requirements. I help advise them on them, and we'll talk about language and we'll talk about the right way to do it. But 9 times out of 10, Amy already knows what to do and how to do it. So what our mind frame is even though it's we're doing the public's business in front of the public, right? And so the public has to be able to trust that process. In the way to do that is not only these laws, but to elevate above the laws. So the 3 areas that I want to talk about related to transparency laws is the economic interest disclosure. That's the Form 700. Those are required. Well, we'll talk about that. And the Brown Act, which everybody hears, you hear this term Brown Act so many times. That's basically an open meeting law. And then the Public Records Act, the other PRA. I mentioned Political Reform Act earlier. This is the Public Records Act. These 3 areas are the legal requirements to make sure that we are allowing the public to know and see what we're doing. So the Form 700 is required under this government code, 87200. It requires certain higher level public servants to file their financial interests. So certainly all you council members have to do this. You got to do it within so many days of taking office. I do it as a city attorney. I know the other department head level people also file Form 700s. So for example, I do have a business in a building in Citrus Heights, and if I disclose that on the Form 700. So if there was an issue related to that, the public would know what my financial interest is in that. And same thing for all of you with where you live, where you work. There's certain requirements in your Form 700, which get sometimes they're a little bit tedious, but there's a reason for that. And planning commissioners, you're certainly going to be required to do it too, since a lot of your decisions deal with land use. So we file the Form 700 upon taking office, upon leaving office, and then every year you got to renew it. If you look on the website, I think the Sacramento County Elections Official has them. You could see everybody's. If you want to go and look and see what City of Folsom City Council members have listed on their Form 700, you can go ahead and look at it. The public has the ability to see where your sources of income are, not necessarily the exact amount, and where your property holdings are and any gifts you've gotten. So it is a required disclosure of your personal financial interests. It's alerting public officials alerts really the public, not a public official, but it alerts the public to conflicts that the public officials may have. So has everybody filled out their Form 700 for this year yet? I won't ask, but that's something we're going to be working on, make sure we've done. I think that's that our city clerk works on. I see a thumbs up from Councilmember Schaefer, so thank you for doing that. I got to make sure I've done mine for that matter. The Brown Act. I think there's a familiarity with everybody about the Brown Act, but there are a lot of nuances to the Brown Act as to really what it covers. But the requirement is that we're going to, everything that, any decision that's going to be made needs to be done openly and for the public to see. So all meetings, and there's a definition of what a meeting is, of a legislative body, and the legislative body for this purpose is City Council and Planning Commission, must be open and must be public. That used to always be a requirement. You had to say, done that in city chambers and let the public come in and watch it, right? But these new COVID rules have really created a weird mix of how this is now handled, right? So there's been several executive orders from the governor that have come down about what we're allowed to now do in terms of running a meeting. And you've all seen it. This meeting is an example. This ordinarily, the special meeting we're in now would have had to be in the council chambers or some public area where people could come and watch it. But the executive order says until this emergency declaration ends, you're allowed to do virtual meetings, which also changes the way even public comment. It used to be you could let people come in and observe the meeting and make public comments. Now public comments are going to have to be in this odd Zoom capacity if they raise their hand, or they can submit written statements to the city clerk up until the meeting, I think even during the meeting. So we're all subject to the Brown Act. Anybody on this meeting, council members and planning commissions, but the other bodies are too. So if you serve in others, those other agencies that you're involved in, make sure they're following the Brown Act, that they are taking minutes, and that somebody is opening meetings up to the public. So planning commission is one of those. That's why primary reason why I attend planning commission meetings is to make sure that the procedural Robert's Rules of Orders and Brown Act issues are being followed. So a meeting is any congregation of a majority. So for the planning commission, that's 4, and city council, that's 3 members of the legislative body in the same time or place to hear, discuss any item within their jurisdiction, right? So any city business needs to happen with a majority of members who are there in front of people. So what we're concerned about is, informal discussions. If you're at the tree lighting ceremony and all 5 council or majority council members or commissioners are there, you're allowed to be there. There are exceptions for social gatherings, but if the public sees 3 of you together talking, they're probably thinking that maybe they're talking about city business. You certainly shouldn't be talking about it. If you're there talking, it's okay to talk about other things, but a majority can't be talking about any kind of city business when they're having informal talks. Telephone conversations, same thing. Serial meetings. So serial meeting is the idea that we're going to have kind of like a chain game, right? So you have one council member maybe talks to another council member who talks to another council member, and now we have 3 council members that are already knowing and talking about a particular item of business. You'll notice that this is talking about a majority. You still are allowed to talk to one other person on your, in theory for the planning commission, you could talk to 2 other people. I wouldn't advise that because I think that's starting to look bad. I think if you want to talk to one other person on your board about an item coming up to your meeting beforehand, that's fine. And that is reasonable. But what wouldn't be okay is if you said, hey, I just talked to Joe. I know he supports this item and here's how I'm going to vote on it. Now we know what's going to happen before it happens.
Commissioner Sheeler, did you have a question?
Yes, Ryan, this recent kerfluffle with the Oakley School Board, I should say.
Yeah.
And at one point, one of the board members says, "Are we alone?" And it was the superintendent, and I frankly don't know how large their board is, and frankly whether all those board members were or a majority were on the call or not. But the question that she said, "Are we alone?" Obviously, like you said, if they weren't discussing board business, then I guess it would be okay to be quote alone. But if certainly if they were discussing board business, that would appear to me to be a violation of the Brown Act.
Yeah, no doubt. I think what they meant by are they alone is they thought they were in closed session. And so they thought, are we alone, meaning the public is not in? And they were wrong. They actually were up and broadcasting for everybody to see. So when they badmouthed their community, it certainly did not go over well. But your point, Commissioner Schiller, is correct in the sense that council members could talk about non-city business if they're alone or somewhere else. It's just, it's hard to keep it to that, one. And really, it's just probably not a good idea for a majority to ever be together to talk about even non-city business. It's allowed, it just has a bad look. And so if they're going to be together, it should be for some kind of special purpose, meaning a retirement or a tree lighting ceremony or something that it makes sense for them to be there. Could be maybe they're all going to League California Cities conference. That would make sense.
Thank you.
You bet. So the bottom bullet, we're going to talk a little more about that, but I am concerned about emails, texts, and social networking and how that interplays, because the law is sort of catching up with this, but it's for a while you could have people engaging on social media posts and they were before council members or people of the same agency were commenting on the same thread. And we always knew as the lawyers that a majority of council members can't do that. And you couldn't express opinion about something that was about to come up. So an agenda item that was about to come up and they're all on their social network together talking about what they think and their views on it. That was problematic. But now AB 992 has thrown a whole new wrench in it, and I'll get to it in a minute. So what meetings are not as individual contacts. Let me go back. We'll go back to the social media in a minute. But it is okay for me, for example, or an employee or an individual in the community to reach out to each one of you independently. So, for example, if there's going to be a new apartment complex that wants to be built in the city and they want to reach out to each individual council member, that's fine. They're allowed to do that. And then we talked about the attendance at a conference. League of California Cities is a good one. They're all allowed to be there as long as they do not discuss issues within their jurisdiction. And then you can also attend other legislative bodies meetings. So if you wanted to go to Sacramento County Board of Supervisors meeting because there was a hot topic issue related to Citrus Heights, you all could be there. Again, you can't sit in the back and talk about collectively, a majority of you, of any city business while you're there. So the email thing is potentially problematic when somebody sends out a group email to the whole council, the whole commission. Anytime I email the city council, which you're allowed to do, we're allowed to provide updates to you all. I will blind copy everybody so you can't reply all to it. But my concern would be if I updated you on some new law and you replied all saying, thanks for the update, that's a dumb law, or I really like, now you've commented on something that's related to city business that the whole council or commission can see. The other issue with emails is the Public Record Act component of it, right? So I think you need to come under have the mindset that anything you write related to city business is potentially disclosable in any format, right? If you're a text, an email, social media, a letter, whatever it may be, potentially could be disclosable under a Public Records Act request, because there are some exceptions that I'll talk about. But for the most part, go in with the mindset that if I wrote it related to city business, it could be turned over.
And Commissioner Sheeler, you have your hand raised?
Yes, go ahead.
If you are receiving, you're not really discussing issues, but you are receiving meeting notifications from the city for planning commissions, whatever else, does that then open the door for the FOIA?
Oh, yeah, definitely. So those, any notices that you're getting from the city staff about upcoming meetings is disclosable. FOIA is the federal law, but the PRA is the same idea. It's going to be it's going to be potentially disclosable for sure. And just because it's disclosable doesn't mean you shouldn't write things. Like, you know, if a constituent wants to email you your thought, you know, their thoughts, that's a good thing. We want to have that interaction, and you can respond back. I'm just saying, when you respond back, realize that what you say could get broadcast in, let's say the SACB asked for a copy of all emails related to a certain project. And in that email back to your constituent, you happen to say something that you regret, inflammatory, whatever the case may be. It's just going to be disclosable. It's not, I don't think the Public Records Act is a problem or a bad thing or something you should be avoiding. It's just, I just want you to be aware that when you write things, it might be broadcast to a broader scope of people than you originally intended.
But your bullet point says it may subject your personal emails and texts to disclosure.
Yeah.
And I guess that's why I was asking the question. I mean,
Yeah. So, meaning your personal text and your personal email addresses on non-city business are not disclosable. The problem is that this is where the bottom bullet says, use your city email address. If you use your Gmail account, your Yahoo account, that you also intermix with your personal emails, and the SACB says, I want all emails for Commissioner Sheeler related to Raising Cane project, I think is one coming up. And what we'll have to do is we'll have to go through the emails, or we'll start by asking you to provide them. You're now going to have to parse out, okay, I'll do a search for Raising Canes and try to find the 2 or 3 emails you might have, but it might be intermixed with a bunch of other personal ones that you'd rather not have to, they're not going to be disclosed, but you'd have to be looked through to try to figure out what is releasable. But if you keep all of your related communications on a separate account, then you just turn it all over and you don't have to worry about having intermixing. Does that help explain what I'm talking about?
yes, it does. I guess I would maybe suggest to clarify your bullet by saying personal emails and texts relating to city business.
Good point. Good point. Yeah, I just wanted people to know that just because an account is a personal account or the cell phone is their personal cell phone doesn't preclude it from the contents of that being disclosed if city business is being conducted on that personal device.
Ryan, regarding the device, I don't think I've heard that before. So if I've got my personal cell phone, since the city doesn't provide me with one,
Yeah.
and I've got my city email on my personal phone, are you indicating then that my phone can be searched because somebody might be wanting to look for Raising Cane?
So the short answer is, well, it's yes, but no one's going to search your phone. What I would do is I would say to everybody, when you get a Public Records Act request, let's say it's all communication related to Raising Cane. I don't know why I picked that one. I would ask you, Councilmember Daniels, I'd say, can you provide me all emails that you have related to that? So you're going to do the searching on your cell phone, not me. And you would then email me. You might say, I have 0, and then we're good. But let's say you only had 2, and you provided those to me. I'm going to disclose those 2 emails. I am not going to go into your cell phone, and nobody's going to go into your cell phone and try to figure out what that is. If there's long-term, like a lawsuit where the company, the SACB or whoever asked for it, didn't think that we disclosed everything, they could in theory ask for a subpoena of those records, but that's quite a ways down the road. Does that help assuage your concerns? I think you're muted.
Brett, mic on.
Sorry about that. It does for the most part. I just didn't remember ever seeing the device aspect of it. I've always seen the email or the social media page or whatever. I just didn't remember seeing device before.
Yeah, it's new. So that's the City of San Jose case that I cited there. That was not the case prior to about 3 years ago. And now there's now the device, you couldn't protect yourself from having to turn over stuff because it's on your personal device if you're using it for city stuff. I just think, I don't want you to think that Big Brother's coming and going to go take your device. We're going to ask you to do your own search and provide that to us.
Ryan,
Yes.
what would happen if you asked, like on a specific subject, can you get the any emails you discussed on your personal email or your personal device? And I replied, or anyone replied, well, I have a personal records retention policy of deleting everything after a month. And I do it every month.
Then
Should
you're
I
in good.
not be deleting stuff?
No, you can delete, you personally, we have requirements, city business, with city employees and certainly police records have to be kept for a certain amount of time. But as a city council member, you have a different obligation in terms of records retention. So if you have an ongoing deletion pattern that your texts or your emails or whatever only stay for so long, that's okay. You only have to provide what you have. I'm not going to make you come up with stuff you don't have or, make you go back and look through the system and try to find something that's not within your possession anymore.
And nowadays, I figure, even though I've deleted it, it exists somewhere in somebody's records because there's a conversation that goes on.
Yeah, and we're not going to go into that unless there's some lawsuit and someone sends a subpoena to Verizon and requests those records. That's a very unique case, and usually for public records, that's not where we're going. It's usually that'd be like a criminal investigation where people do that kind of research. So I didn't mean to freak everybody out on this one.
You did.
All right, sorry about that. So texting, the same thing with emails. If it's still on your device, my texts only stay on for so long. But if they're on your phone, a screenshot of those might be discoverable for a Public Records Act request. I did have some bullet points there about, be careful about avoiding sending texts or emails during the meeting itself. That was what the city of San Jose case was about. They were asking, they noticed that it looked like there was some kind of conversations going on the members' devices during the meeting. And so those ended up being disclosable to the extent there wasn't a exclusion. So sorry, my slides are a little bit out of order, but the social media policy, this law doesn't make sense to me because it used to always be that you needed a majority, 3 council members or 4 commissioners to talk before you had an issue. Under AB 992, it is saying that a council member or a commissioner can't comment or even like or even put an emoji after the comments of another council member's thing related to city business. Like if you had a new daughter or granddaughter born and you say congratulations, everybody can emoji or friend that. But if there's city business that's being discussed on social media, please don't comment on other members' posts. If you each want to do your own separately and not comment on each other, that would be fine. So is that all? Maybe you share my head scratching in the why did that when any business requires 3 people, but at this point they're treating social media differently than other venues. So this is foot stomping what I said is, even liking or emojiing somebody else can be a violation of the act. I don't know what the repercussions are, but it's still not worth getting into. Any thoughts or comments before I move on?
The only thing I think that's weird is, I think all of us are on social media. So if one council member writes an opinion on an upcoming issue, the other 4 are reading it. That's a serial meeting in my mind. Even though we're not posting or responding, it's the information's we're seeing it on a thread.
Yeah, but okay, good point. But I think you bring up a different point, which is you're allowed to express global opinions. You can't say how you're going to vote. So if somebody is saying, I'm going to vote no on this or yes on this, that's not allowed anyway, whether it's
right.
1, 2 people, 3 people, 4 people, because now you're disclosing, your disposition on how you're going to vote. You're required to have an open mind into the meeting as you hear public comment, listen to the staff presentation, and then vote. So,
Yeah.
but I understand your point. If people are just making opinions, hey, I generally like this, don't like this, that's okay. You just got to be careful that doesn't cross into how I'm going to vote. And I think everybody gets that, right?
It's tough. I try and stick to puppies and grandkids.
Probably smart. So posting requirements, this is city clerk business. Regular meetings have to be posted 3 days in advance. Special meetings are 24 hours in advance. We got to post it on the website as well as physically on the building. What we're putting in the posting is where the meeting is going to be held, the exact time, and you have to give a general description of each item, including closed session items. The public wants to know what we're about to talk about. So if you're going to, every once in a while, I will interject in a council meeting and say, we're going off topic, because that's not fair to the public who didn't see that particular item on the agenda. And now we're talking about something that's not agendized. So it's not because I'm trying to be a jerk or anything. It's trying to keep us within the Brown Act on that. So yeah, we can't have any action or even discussion on items not appearing on the posting agenda. There are some very few exceptions. So an emergency, if we had a water main break that happened right before the meeting, you can have an emergency item for immediate action to take care of that. You need a 2/3 vote or a 4/5 vote of the council to bring up an emergency agenda item. That hasn't happened since I've been here, but it certainly could. Brief responses to question comments from the public. So a lot of times public will ask really good or make really good comments and really good statements that you're like, I really want to comment on this. I would love to engage this discussion, but we're not allowed to. So the right response or the legal response to somebody who's making a great comment, and then they look at the 5 of you up there and like, why aren't you talking to me, or why don't you engage? The answer, I think, is we've got to, maybe it's usually the mayor will say, we appreciate your comments, thank you, but under the Brown Act, we can't engage in a conversation about it. I would direct you to city staff and work with them on that topic after the meeting, if that's something that is appropriate. But we can't engage in a back and forth on a non-agendized item. And then reports from board, it says board members, really council members or staff. Staff doesn't do reports as much, but on planning commissioners and council members, the point of that is we're advising people of work we've done. We got to be careful about not getting into non-agendized items. And that's again, where I could step in if I think we're getting off topic. Now, we do at the end of meetings request to agendize future items. And that is, the discussion on that needs to be, is there interest in talking about the item, not the item itself? And that's a really hard one to do, and I try to let that go to the extent we can. But every once in a while, the substance of the discussion gets too much, as opposed to just, do we want to talk about this or not? Closed session, there's some very particular items we can talk about in closed session. Usually it's real estate negotiations. You can talk about legal lawsuits that are pending, talk about personnel action, but a lot of times it doesn't happen so much in Citrus Heights, but I've had before where I've been asked, well, let's talk about this and let's talk about this item in closed session. Like, well, we can't go there because it's not one of these 5 or 6 very specific items that are allowed to be discussed in closed session. And then disclosure of anything discussed there is illegal. Well, the Oakley situation is different, but that's the idea. You can't, what stays in there what happens in there should stay in there. Consequences of Brown Act violations, so we could nullify the decision, meaning we got to redo it and there's also criminal sanctions and usually the media attention related. If you have a Brown Act violation, that's kind of looking like a lack of transparency, which is not a good look for the city. I wanted to talk a little bit about Public Records Act. We mentioned it before, related to that City of San Jose case, but it does apply to any writing containing information relating to city business. Could be agendas, could be other documents, correspondence, photographs, tape recordings. We get Public Records Act requests all the time. The police gets them a lot. There's just, it's kind of an ongoing thing that anybody can ask for. The most typical requester is a media outlet or a citizen, but even somebody who doesn't name themselves and even somebody who doesn't live in our jurisdiction is still entitled to a whole bunch of all these public records. And the concern in some jurisdictions, again, we don't have it here, is you can have people who take advantage of that, and they're just bombarding you with Public Records Act requests. And if they get to be at a point where they are too voluminous, you can try to push back. But for the most part, we're disclosing anything we have, and unless there is a very specific exception that we'll talk about. So the records must be available either to provide a copy. Usually what we do is we'll provide an electronic copy to them, or they could come in and look at them to inspect them if it's too big. If it's, an item that is going to be expensive to produce, we'll let them know they can come into City Hall and look at it. If they want a duplication, we do ask that they pay a duplication fee. We want the request to be focused and specific. That's when I will push back on a request that says, hey, can I have all records relating to the police department? Okay, well, that's just crazy. Or if there's something that doesn't have a date or a name of who we're looking for, I can ask for a more focused and specific. Otherwise, we'll be going on a wild goose chase. Our response time is really quick. We only have 10 days to provide these. So when Amy gets these or the police department gets them, we're cranking right away trying to get back. You can't ask for an extension, but our goal is to try to provide records within those 10 days. But sometimes we at least need to communicate with them in the 10 days and maybe tell them we need more time. If there is going to be a denial, we're going to state the names of the persons who are responsible for that denial. Could be city clerk or me. But really, the public has a right to these records, but also assistance from the agency. And a lot of times they don't know what they're looking for, and they'll ask records vaguely. We'll get engaged in a back and forth with them to say, what is it you're looking for? Let us help you try to figure it out. And that's something that we do. So certain things are exempted. Again, I think the going in point should be that all the records we have are going to be disclosable, but there are some things. Anything that's in draft format is not going to be disclosable. Pending litigation is not going to be disclosable. And communication from your attorneys would not be disclosable because that should be confidential as well. Complaints and investigations, personnel records, there are some exceptions to that. And peace officer records have a whole special law called pitches motions when they try to seek police records. Then there's some other things like financial data, trade secrets, security stuff. So we're not going to provide, if someone asks for records on what our security plan is for City Hall, we're not going to, or the police response on something, we don't provide those. There is a catch-all that if we think it's in the public interest not to disclose, but I try not to use that one. A little bit, we already kind of talked about the email disclosure and how that would work. City of San Jose case really opened that up quite a bit, but just be aware that emails even contained on personal device could be disclosable. So the court could order production of it, and they also could award costs and fees, and there's always immediate attention if you have a problem with the Public Records Act. So let's assume all information is public, and I think we don't want to discuss amongst yourselves with other decision makers city business outside of a public meeting. Any question on that before we finish and conclude? We're kind of in a home stretch here finally. I want to talk about fair process laws, and this is the guiding principle is that as a decision maker, the public expects that you're impartial and you're avoiding favoritism. So we got these types of, there's bias, due process requirements, something called incompatible offices. competitive bidding on contracts, and the nepotism laws. So due process administrative hearings does demand that you're fair and impartial, as we talked about before. This kind of goes with that concept of you shouldn't make any comments before that meeting about how you're going to vote. Because what somebody could ask is that we're going to have to recuse yourself now because you've shown that inelastic disposition for your thoughts on a particular topic. So that last bullet is, strong opinions are okay, but you can't have a closed mind. And this was the example is a Newport Beach case, which I think is pretty clear. The council member there didn't like the decision that a planning commission had made and appealed it. So I don't know if you knew this, but the city council member does have the right to appeal planning commission action. But when that action then comes to the city council for a vote, if you were the one who appealed it, you now have basically said how you're going to vote, which is you don't think the planning commission got it right. You'd have to step down as your role as city council member. But in Newport Beach, this council member said, no, I'm going to stay on the dais and vote on this item that I personally appealed. And the court said, sorry, that's not how it works. I want to be careful of being personally embroiled in a matter. Doing personal field investigations. That was one in this particular case. This is an old case from '78 where some members of an agency were personally doing investigations on, it was either a fire chief or a police chief's activities, and then they adopted a resolution that was unsubstantiated some of those findings based on the research that they had done. So that, again, to the extent possible, we have professional staff or people to do a lot of the field work. Doesn't mean you can't get public input or get a lot of information, especially from staff, but be careful about how deep you personally get involved into investigation. So due process, what we're going to do is you're going to notice the applicant gets to note of the intended action, an opportunity to prepare their case, an opportunity to be heard, and to have a fair and impartial hearing. It's generally acceptable to express opinions on community concerns. That's okay. We want council members to attend community meetings on matters of interest and gather that kind of information. That's helpful. And prior knowledge and factual background is okay. Campaign statements is always a funny one because people during campaign season say all kinds of stuff related to their feelings because they're asked all the time. And I would say, first off, be careful about what you say in campaign statements because they could come back and maybe make a conflict. But usually the courts are going to say what people say in campaign season is acceptable behavior. And then what they say later when they actually get elected, they usually don't have a conflict, especially if they could say, look, that was during my campaigning. Now I'm in the seat and I can be fair and open about this decision. Incompatible offices is when people try to hold two different offices at once. For example, you couldn't be a planning commissioner and a city council member. There's also Attorney General's opinions about being on like a school board within the jurisdiction where you serve and being a city council member. That is considered an incompatible office. What the rule is saying is if you ever have to figure out who you're following, where your allegiance is to, the public doesn't know. Is it to this entity or this entity? Then you have an incompatible office and you have to pick one or the other. You can't hold both at once. And so if you do seat into two offices, it's considered that whichever one you seated, officer deemed to forfeit your first office, the original one, upon seating for the second office. So if you were a school board member in the San Juan Unified School District and then became a city council member after, you would automatically forfeit your seat on the school board. Now, it doesn't apply to government body with only advisory powers. Now, everybody on this call has actual legislative powers, so it's not the case. But if you're in some other agency where you don't have a voting right on something, then it wouldn't matter. You could be on both. You could be on a school board and then also a neighborhood committee or something like that.
Ryan, this is to elected or elected and appointed. So if you served on the board of a nonprofit, that would be okay.
That is going to be okay, but it could be elected and elected, or elected. It's generally going to be elected and appointed, but there are other entities out there that you might be incompatible office, but the one you're talking about there, that would not be. Being on a nonprofit board, you might have to recuse yourself from a vote relating to that, but they're not incompatible in the sense that you can't be on both.
Thank you.
You're welcome. All right, we're coming down to the end here. Competitive bidding. This is something that is by state law. You gotta put projects out for bidding out of fairness. Any public works contract over 5,000 has to be publicly bid. Those are very specific. Public works is not a specialized contract like engineering services or legal services. It's for, no kidding, like construction work. And you have to go with the lowest responsible bidder. So that's why you want to make sure your bid documents are really well done. And we work on that because you by law, have to go with whoever's the lowest bidder, as long as they're a quote responsible bidder. If they can't meet the bidding requirements, then they wouldn't be a responsive bidder. There are some exceptions on professional services, emergencies. You don't have to do competitive bidding. You can reject all bids and put it back out to bidding if maybe they're all too high. So here's what happens if you do violate. This is we get bid protests sometimes where it happens either maybe the contract's going to be void if we did violate competitive bidding laws, and it's hard to fix that in a lot of ways. And we do, at the bottom, I want to mention, we have a purchasing policy in Citrus Heights. So there are certain issues, certain level of expenditures that require city council action, certain levels of expenditures that I'll authorize the city manager to spend money, or certain and even lower levels where department heads could spend money based on our purchasing policy. But that's on non-public works projects. Those have to go out to competitive bidding.
Commissioner Sheeler, did you have a question?
Previous slide, Ryan, I used to be the chief engineer for the Port of Sacramento, and the issue came up a number of times about basically something costing back then. I think the limit was at one point $15,000 and then $10,000. Splitting up a contract into 3 or 4 or 5 POs to try to get around the bidding process.
Yep, people try to do that all the time. That's what that bottom bullet there is. And I skipped over. I'm glad you brought that up. You can't split projects to avoid bidding. So if you want to parse it all up, hey, it was $4,999 for this piece and this piece and this piece. That's called bid splitting, and that's an inappropriate way to get under the competitive bidding process. Thanks for bringing that up. I don't think anti-nepotism, it's really not. There's rules about hiring people that you're related to. Again, a fairness and a perception issue. So I think we're right at the last couple slides and we're at 6:59. So in my mind, I want you to try to think about what the fairness is. We're going to go with merit-based decisions and try to keep the politics, separate from your decision-making, I guess, if that's possible. But the lessons are we want this to be a minimum standard for behavior is our ethics. We have laws that we're going to follow, but let's try to go above and beyond that, because the laws, the penalties are potentially stiff, and it's about transparency for the community. And I really like the FPPC in terms of using them as a resource. Their website has great work. I do call them on occasion as a resource because they have attorneys on call who will give you opinions on issues, and they can be very helpful. And sometimes the AG has opinions from previous cases that we can use, and I find them to be helpful. So. All right, guys, 7 o'clock. Thank you for your attention. I really appreciate it. I hope that it was helpful to you all. You're good for 2 years now. Yep. Questions, or what can I?
Well, I don't see any questions. I wanted to thank you for your presentation. No, if there are questions, please raise your hand for Amy.
Thank you, Ryan. We kept moving along.
You're all very welcome. Have a good rest of your week.
Okay, thanks so much.
Well done, Ryan. Thank you.
Thank you, everyone.
Brian.
Good night.